4 minutes late, so on time, basically, right, for the after lunch session. I figure, why don't we go ahead and get started and see where we end up. We have more people in the audience than on the panel, so that's a good start, at least, to our little after lunch discussion. And I recognize that many people are jet lagged, and many people have just eaten, so we will try to keep this lively and an upbeat discussion. Welcome. This is a panel that we put together to talk about some of the issues and trends in international trade secret litigation. We've included in the materials that I think pretty much nobody has probably looked at some slides that have some information, background on trade secret litigation in the US, Europe, and Korea, some of the relevant legal provisions and international agreements, and some data on trends in trade secret litigation. So feel free to look at that. I think it exists principally so people can get CLE credit, so it is there, and feel free to peruse it. When we think about trade secret litigation across borders, one of the things that I at least think about is that a trade secret claim or trade secret misappropriation claim is different in many respects than other types of IP claims that might be drawn. It's fundamentally about conduct, and it's a business tort type of claim where the objective is to ensure that there is protection or an ability by firms to protect their trade secrets. The claim itself, right, is premised on wrongful conduct or unfair trade practices by one party that disadvantages another commercial firm. And in the international context, when we think about claims across borders, that raises unique questions that differ in some respects from patent claims or other types of IP claims. What law should apply? Where should cases be filed? Whose rights are protectable in what jurisdictions? Are there public policy considerations that may be relevant? What remedies are available, both at the initial stage and at the ultimate stage if a claim can be established? How is proof going to be established? What tools are available to develop evidence, and what are the standards of proof that are required to be met? What law applies and defines what the wrongful conduct is? And what do you do if you're faced with claims in multiple jurisdictions arising out of the same conduct? Or as we see in some cases, countervailing claims, one party claiming in one jurisdiction against another, and the other party bringing claims that go the other way in another jurisdiction. I'm going to throw those questions out and not answer a single one of them because we have an excellent panel today to speak to them. So why don't I take just a moment and introduce them, and then we'll jump into the discussion. Like I said, I hope we can keep this up here, energy-wise. So feel free to raise your hand, ask questions, make comments, heckle, disagree. That'll be fun. So to my right is Duxin Chang. He's a preeminent senior intellectual property litigator at Kim & Cheng. In addition to leading some of the two largest patent lawsuits in Korean history, leading many high-profile cases on the plaintiff and defense side, Duxin also routinely serves as neutral in IP cases. Since 2009, he's been leading the Intellectual Property Training Institute, the Seoul Bar Association. That's a very short summary of a very long and distinguished career, so I apologize if I've left things out. To his right is Tae-Jun Kim. He's a partner in the intellectual property group at Day-Finley, where he focuses on intellectual property litigation in IP transactional matters. Mr. Kim's background includes both multi-jurisdictional IP litigation and acting as Korean counsel to clients involved in foreign litigation. To his right is Albert Lee. Albert is a senior intellectual property lawyer currently at Advancing, a boutique patent firm here in Seoul. His practice focuses on business-focused IP solutions, including advising clients on portfolio protection strategies, monetization and enforcement efforts. He's formerly a patent examiner at the U.S. Patent and Trademark Office and previously served as a senior in-house counsel at Hanwha and LG. So he brings the in-house perspective to our panel here. And last but certainly not least, to his right is Tae-Jun Chang, a partner in the intellectual property practice at Lee & Co., where he represents and counsels clients on a broad array array of IP matters, even on jet including patents and trademarks and design practice. And he has in particular a broad range of litigation experience, both domestic and international cases involving unfair competition and trade secret protection. I've had the great opportunity to speak with these gentlemen in connection with putting together this panel, and they have a wealth of experience, different perspectives, and a great depth of commentary on the proceedings here in Korea and in the international space. Looking forward to this discussion. So I didn't introduce myself. My name is Noel Bamberger. I'm a partner in the litigation group at Cleary Gottman, based in Washington. For the past 10 years or so, my practice has involved a particular focus on clients in the Asia Pacific region. I was based in our office in Hong Kong in 2014 for about a year. And part of my practice, but not all of it, is in the intellectual property litigation space, principally cross-border disputes. So I don't claim to be an expert, but hopefully I can ask a big question. So before jumping in, I was asked to mention, this is my pitch, the ILS's upcoming publication of the International Practitioner Desk Series, International Litigation Strategies and Practice, the third edition, by Ethan Berghoff and Theodore Edelman, which will be published upcoming on January 2nd, 2024. It promises to be an excellent resource addressing some of the issues that we'll talk about today and many, many others. So I recommend it, although it hasn't come out yet, I haven't read it. And I note that it's available to people in the registration desk. So now that I've done the commercial side of my introduction, let me jump into our panel discussion by posing some questions to our panelists. I'll start with the question that I'll ask each of you to answer, which is share a little bit about your experiences in multi-jurisdictional IP and trade secret litigation, focus on some of the issues that we've talked about. That's the key question.
First of all, thank you, Noel, for the kind introduction and laying a good foundation for today's panel discussion. Yes, I have been involved in a number of multinational IP litigations, broadly speaking, in several different contexts. In majority cases, I have handled into the context where two global competitors litigating against each other in multiple jurisdictions is the ultimate goal of securing better terms in cross-license between them. In that context, if one party obtains an injunction in a Asian market that is immediately or provisionally enforceable, despite the losing party's appeal, that will work as a huge leverage for the prevailing party in the cross-license negotiation. So under that context, whether injunction remedy is available and whether an injunction is provisionally enforceable despite the losing party's appeal, and how quickly you can obtain the injunction were key issues in determining where to bring the litigation among the multiple choices. Also, a multiple IP litigation often arises when an original drug company is facing challenges from generic producers in individual countries against the patents the original company has registered for a certain drug in each country. In that context, the original drug company, the patentee, has to fight against different counterparts. In other words, the generic producers in each country. In terms of IP rights that are asserted in multinational litigations, I have the impression that whereas patents, where we can often find being litigated in multiple countries, it seems rare to find the trade secret litigations to take place in multiple jurisdictions concurrently. I thought about the reason for that. I think it is probably because an invention can be registered in each country as an independent right, and they may be infringed by another competitor in multiple countries. Whereas in case of trade secret, an act of misappropriating trade secret would typically occur perhaps in one specific country. In any event, interestingly, there were a few US ITC cases recently where both complainant and respondent were Korean companies, and the alleged misappropriation of trade secrets occurred in Korea. The Korean complainants reportedly chose to file an action before the US ITC against its Korean competitors, among others, considering the broad discoverability before the ITC. I will stop here and will explain a little more about those Korean cases.
Thank you, Jackson. Shall we simply go down the line? Everybody? I have two microphones and you have none, so this one might be better. It's like the 80s, we had cords.
I will make my short answer to this, including the cases that Dr. mentioned, the cases between Korean companies before the ITC. I have experienced numerous multinational IP merits, directly, indirectly. My experience is not limited to dispute matters. I dealt with many kinds of cross-border IP transactions. In such non-dispute advisory matters, insight from global IP dispute is very helpful. That's because one of the main purposes of such advice is to avoid potential dispute. So, yeah. I end my lesson here and I will share my experience with the following questions. Thank you.
Okay, just to add to Dustin and Peggy, of course, Hyun will speak after. Because I worked 10 years in-house, and because business is global, and if your business is related to technology, patents provide protection for that technology. So, and because your products are sold around the world, global litigation is always an issue. And hopefully today I can share some of my experiences.
Thank you for this opportunity to share my thoughts with you and the respective colleagues here. Yeah, I recently think about my past and my job history, and I worked with many international cases, but most of them was patent cases. And I involved in several years ago a big international trade secret case between Korean company and Japanese company. But the case was also one of the case of the broad IP dispute. And in some country there's a patent dispute, in some country there's trade secret dispute. So as Dustin practice said, it is not very common you have international multi-jurisdictional trade secret case. The reason is maybe trade secret case can be resolved in one country because of this nature of the legal issue. And the other issue is the patent is independent in every country. So patent claim can be different in one country to another. So you have to go to different countries to pursue your right. But trade secret case, yeah, if you have a trade secret, then you can claim it in any country, same way of the other country. So maybe it is the reason. But still, you have to understand this is only a part of the global IP dispute. So this trade secret is just one of the weapons, not sole weapon. So if you think about trade secret dispute, then you also have to think about the patent dispute and other design patent or trade secret, trademark, everything. So yeah, I will talk more about this issue and the different systems in different countries.
broke it. All right. Well, thank you for that, those introductory remarks. If we think about the principal risks that are faced by a party that is subject to IP litigation or trade secret litigation, either in multiple jurisdictions or outside of its own jurisdiction, what comes to mind? What do you think?
Well, I'd like to think about some aspects of proof or evidence in the context of multinational IP litigations. Of course, there are many factors you need to consider in determining where to litigate when infringement takes place in multiple countries. I think one of the key factors would be whether you can effectively obtain the infringement evidence from the opposing party. In that context, Korea does not have such extensive discovery, which is available in the US. And we do not have the discovery and trial, which are conducted in two separate phases. Once a complaint is served and the defendant's answer is served, then the court will conduct a series of hearings, monthly or bi-monthly, until the case is ripe for the decision. The limited discovery is conducted during and throughout the hearing procedures. And each and every type of discovery needs court permission and conducted by or supervised by the court. So perhaps US practitioners cannot imagine when the court approves a party's request for inspection over the other party's premises, the court goes out to the premises together with the counsels of the parties. So discovery is really conducted by the court. And no open-ended and broad discovery requests are allowed. I will just shortly mention to Korea's reservation about the pre-trial discovery under the context of Hague Evidence Convention. So you need to be specific, or should be able to provide some particularity when you request for document production. So such limited discovery in Korea makes it more difficult to litigate the trade secret issues through civil proceedings, because most misappropriation of trade secrets takes place in a manner that cannot be ascertainable from publicly available final products. So as I said, a few Korean companies recently chose to file IT sanction when they had the parallel Korean civil and criminal actions, because they couldn't get infringement evidence from the Korean civil action, and also since they failed to have the search and seizure carried out over the other party at an initial stage of the Korean criminal litigation. That is one thing. And then secondly, you can consider whether you can get evidence abroad. I can think of two routes. One is Hague Convention, as I mentioned. So one signatory country may issue a request, letters of request to another signatory country where the evidence is located. When acceding to the Hague Evidence Convention, the Korea made a reservation for the pre-trial discovery for documents. Here I would like to emphasize the documents. The reservation declaration is silent on the witness examination. So it would be fair to say that the Hague Convention, the letters of request under the Hague Convention will be accepted even if they are issued by the US court during the stage of pretrial discovery. Only broadly defined document production requests will be rejected by Korean court administration. So, based on my own experience, we have more success on the witness examination requests compared to the document production requests. But still, even for document production requests under the letters of request, was successful in the event the wordings of the request were carefully drafted in such a way just to avoid very broadening terms such as any and all, and if any, and particularly the term discovery, regardless of what is the substance of those words under the context. It seems that the Korean court sensitively responds to such descriptions. And in case of witness examination, definitely that is conducted in accordance with our own procedural law, and therefore you need to submit a written questionnaires in advance. And those written questionnaires will be used for witnessing the examination before the judges. So private testimony taking is not allowed or conducted in Korea. And the second way of obtaining evidence from abroad is the 1782, Section 1782 motion under perhaps US Code 28.
You got it.
Yeah,
You got it.
28, Title 28. That statute allows a foreign party to get evidence through US court for foreign proceedings. So I believe there would be at least several cases where the 1782 was successfully used for the Korean proceedings. However, based on my limited experience, it seems US court are very willing to issue the 1782 motion grant. However, there is a practical difficulties. In many instances, the 1782 motion is granted under US protective order, particularly the attorney eyes only. We have protective order system in Korea for patent and trademark, trade secret litigations only. We do not have protective order system in broad civil litigation. But we do not have attorney eyes only type protective order under our patent and trade secret actions. So, although we obtained through US counsel the evidence through 1782, it is another matter whether and how we can use that evidence for Korean litigation in a manner compliant with the US protective order. That is one of the serious issues we encounter from time to time. And lastly, how to use the evidence obtained in one jurisdiction for another. As I said, in the trade secret cases, the Korean companies resorted to the US ITC in view of inability or limited inability in Korea to obtain evidence from the opposing party. So in one of those cases, the Korean company successfully used the evidence generated and produced in the ITC proceedings for Korean litigation. Those information were produced under the attorney eyes only. But in Korea, there is no attorney eyes only, so there was no way for us to use that. So we could persuade the other party to agree to the use of those proceedings under certain conditions, and we succeeded in persuading the judge to accept the party's agreement. So very exceptionally, those proceedings were conducted in a manner of complying with the attorney eyes only proceedings. But you cannot expect all the other parties to agree with the use of the evidence obtained in the state, and also you cannot expect all the Korean judges would agree with such type of proceedings. And therefore, some novel issues will arise, and therefore you need to carefully consider in advance and cautiously address that issue during the course of proceedings. That's it.
Let me ask a follow-up question, because I know there are others who wanted to bring on that question, but just before we do that. When I think about filing a trade secret case, one of the things I'm worried about for my client is the amount of information they will have to disclose. Because, of course, when you to bring a case to establish a claim, you're going to have to disclose the trade secret, at least for the judge and their such lawyers. What you said about not having attorney's eyes only protective orders in Korea scares me as somebody who's advising a client who might be bringing a claim in Korea. How does that work? Do the other side's internal employees have access to information that is put forward as evidence?
I think my colleagues will be able to provide more accurate answers, but my broad answer is trade secret litigations existed even before we introduced the protective order system for trade secret litigation. So what we do is the court says that the plaintiff needs to identify the trade secret so to be protected in a manner the other party could understand what it means, without a need to provide each and every details of the trade secrets. And more serious issue I recall, if I understand correctly, we have one Supreme Court decision that you cannot seek protective order for the trade secrets you state in the complaint, which is being sought to be protected. Because your allegation is based on the theory that the other party already unlawfully and illegally obtained the trade secret. So if the protective order is approved, that could be tantamount to granting the remedies at the early stage of the proceedings. So I can easily understand that precedent, although logically that may make sense, but perhaps I think our colleagues may make more comments on that.
I think that, yeah, Charles' comment is very correct, and I can add just a little thing. First of all, we have different docket system in Korea. So if you go to US, you can search for a company like Google, and you can see all the documents from the research. But you cannot do that in Korea. You don't know the parties filed the lawsuit or not. So without the knowledge of the party's name and the case number, you cannot identify the case. And even if you identify the case, you cannot see the documents. And if you want to see the document, you have to request to the court. Only if the court allows, then you can get a copy of the report. So yes, it is very correct that the protective order does not work in Korea, but sometimes it is not necessary because no one knows. And the other one is that usually in the trade secret cases, the complaint, the plaintiff file a lawsuit, and usually it goes to criminal case because it is the difference in difficulty in getting evidence. So if you go to police and police go to the other party's premises by dawn late without any notice and search and see the documents, and then you go to the police office and then you identify this is my secret, this is my trade secret. So that's the procedure. So in the procedure, I personally see not many cases that the plaintiff does not want to disclose his trade secret first. Usually the case is the other way around, that the defendant does not want to disclose what they have, but the police search and seize, and the plaintiff identify this is mine. So this is a practical procedure. But I agree that there's a concern that the plaintiff may have to disclose their trade secret first to identify their client.
According to my limited experience, this is a very debated issue. I feel that this is an unsolved question, that is solved. From defendant side, he needed to know the exact information of the trade secret, what plaintiff claims that this is the trade secret to defend the claims. So every single case that I expressed related to trade secret, this issue is solved at the beginning. In every cases, there has been this kind of debate in the beginning.
Although I mentioned the Supreme Court precedent, and also it is true that in one local case where we applied for the protective order for the trade secret we were asserting, the district court rejected our application based on that Supreme Court precedent. However, as I explained in one of the trade secret case which was taking place before the ITC had parallel action in Korea, when we used the US produced evidence for Korean proceedings, that specific court just appreciated the need of protective order, so it issued the protective order. However, just one thing I'd like to add is there is a great difference between the protective order system in Korea and in the US. As I understand, in the US, at an early stage, you just stipulate to the protective order. So that will cover any and all subsequent submissions of documents between the parties. However, in Korea, the protective order should be sought each and every time you submit documents or evidence which contain the confidential information. So in one case, I believe we had to submit, both parties had to submit more than 40 or 50 PO orders, and the court had to issue the PO orders with description of information which is to be protected by that order, and with a list of people who are allowed to access those information and the subject to confidential documentation.
It's interesting, actually, because in the U.S., you're right, that when the case is initially filed, typically the parties will have a stipulator, the court will issue a protective order that governs the exchange of confidential information between the parties. As you start filing proceedings in at least district court, though, how you point, because the docket is public and there's a public interest in information, the closer you get to fact-finding, the less ability you have to avoid disclosing information. Now, the courts will almost always allow you to seal or avoid disclosing trade secret information, but it almost becomes a funnel in the U.S., where at the very beginning, information is exchanged freely, and at least in district court litigation in the U.S., once you get to the summary judgment proceedings, or certainly a trial, the amount of information that the court will permit you to avoid disclosing becomes much narrower. So it's not totally dissimilar from the Korean system, although I can't imagine a judge issuing 50 different protective orders.
Just a brief comment from the in-house counsel standpoint. A lot of these trade secret disputes occur because one of my former engineers goes to a competitor, right? And maybe he took some of our secrets and they're making products. Because obtaining evidence in Korea is so difficult, for example, even damage assessment is difficult because the other side doesn't tell their financial information and it's not available publicly. But as in-house, for trade secrets, you have to keep it trade secret, right? There are certain procedures that you need to follow. So from my experience, I think education is very important. in-house standard. You have to tell your people to be careful what you write, what you say, who you meet, and so on.
Moving on from that topic, perhaps, we spoke about risks, and I think we touched on some of the issues more broadly that parties have when litigating these cases across borders. But I'd be interested in talking a little bit about what are the opportunities for a claimant who may have the ability to bring a claim in more than one forum. When you're advising a client, thinking about where to file a case, whether their home jurisdiction, the jurisdiction the alleged infringement occurred in, misappropriation occurred in, or another jurisdiction, how do you think about those issues? And I'm going to start on that topic.
Yeah, okay. So, because I represent some claims, but I represent a lot of defendants. So I more like a defensive side. So when you think about all the different jurisdictions, if you understand the differences and pros and cons, then you can pick one, or you can pick multiple jurisdictions. As I said, Germany is very fast in patent infringement actions, so you can go to Germany to start a patent infringement action. And in Korea, you can make this basic claim as a criminal procedure. So you file a criminal complaint to the office, police office or prosecutor's office, and they review it, and they think that there is some merit. They will go and seizure the documents and evidence. So if you can use that procedure, this is psychologically and also procedurally very beneficial. You get all the documents obtained by the government authority, and you can use it for the civil lawsuit as evidence. So usually you get the decision in the criminal case first, and use the record as evidence in the civil case. So that is very beneficial for plaintiff. So you can also think about it. And also in Korea, there's a kind of NCT, National Core Technology issue. This is a pros and cons, but if you have the very important technology, it may be trade secret, but also it is the national core technology. And if you make that claim, this is very serious, the civil claim, but also it is one of the most important issue to NSC, the Korean CIA. So they will maybe get involved, and this is a very big issue. But on the other side, if you have trade secret and you have litigation outside Korea, and they seek trade secret is a national core technology, it is very limited to provide the document information to outside counsel, because under the Korean regulation, providing information to the outside counsel in the outside Korea, it is export technology. So they need approval before providing information to outside counsel. So we experienced that kind of issue before, that we have litigation in the US, and Korean company have to provide information to the US counsel in the US, and then there's some dispute whether we need approval from the government before providing information or evidence to the other party. And if you have a discovery in the US, this is very serious. Discovery is very expensive collection and production of documents. But if you have any national core technology among the documents, then you have to get approval first. So, yeah, as a defensive side, you can try to refuse to produce a document based on that kind of regulation. And I'm not sure how the US courts see the documents, but under the Korean law, we need to get approval first. So this is our tactics. And if you understand the legal landscape of each country, then you can use it. Yeah. And also, I experienced some case, we had maybe 4 different countries had a parallel litigation. And in one country we lost, and the loss was kind of very frustrating. Yeah. So we argued kind of 3 different points, and we clearly lost all the points, and the judge was not in our side. So we were very frustrated in that case, But in other country, we won, we got injunction. And the third country, the litigation takes so long, so it even started the first hearing. So in that scenario, you can continue the litigation until you get settlement. So even if you lost in one case, if you won the other country, then you have a leverage and you can still settle. So having multiple jurisdiction litigation is sometimes good. It's kind of reduce the risk. And you can put all the eggs in one basket. Right? So that's my practical experience in arbitration.
I want to add an explanation about the entity-related case that I mentioned. This is related to Korean companies' submission of evidence in other jurisdictions. In case any data collected in Korea is submitted to overseas dispute as evidence, the Korean government considers it as a matter subject to export control, which can take several months. That will cause a significant delay in evidence production and the overall case. The first prominent case where this kind of export control applied to Elvin Ken versus SAI before the US Federal Court and US ITC. In that case, technology involving rechargeable battery for electric vehicle was an issue, which technology was designated by Korean government as an NCT, National Court Technology. And such technology was included in the evidence that LGCAM and SKI were requested to submit to the US Court and ITC. And the position of the Korean government has been that submission of the evidence containing national court technology to overseas dispute is also considered export control, which needs approval or reporting before the Korean government. Both parties conducted such a regulatory procedure under the Korean export control law, submitted the evidence to US cases. The review by the Korean government conducted on whether the evidence contains NCT, and also the review conducted on whether the evidence needs to be submitted to the US cases. In the end, the submit was able to be submitted to the US Federal Court and US ITC, but it make a significant delay in the case. The more recent case is between Korean companies case. This kind of export control became issue in the more recent case between two Korean companies. In that case, the Korean companies used that the foreign companies' inspection of the document, facility, or substance related to the national court technology is also subject to export control. This means that unless the Korean government provides approval, the parties' US attorneys cannot review the crucial information relevant to the case. In that case, this review process caused significant delay to the whole case. Almost 1 year. So this is something to be aware of when dealing with the case related to data or technology that is subject to Korean export control law.
One final comment. As claimant, as plaintiff, it's great to have choices, right? And then you can decide maybe just sue in one country. But global litigation, from in-house standpoint, it can get expensive very quickly. So cost control. That's my last one.
Looking like an in-house lawyer. The export control issue is an important one, and having had some experience dealing with that in Korea myself and in some other jurisdictions. I've heard in connection with some of the other panels about restrictions on information export from mainland China as well, and other countries have similar regimes. To me, at least, it seems like the sort of thing really, if you're planning to bring a claim, need to be thought through before you file the claim. Because while you may get some sympathy from the courts if you're subject to a restriction on export that you really can't do anything about, if you're the claimant or you brought the case, particularly if you brought it in a foreign jurisdiction, at least my experience is the courts are not going to be particularly sympathetic to obstacles you have in producing evidence. And as there is, I think, a different standard applied as between the complainants and the respondents and plaintiffs and defendants. Can we talk for a second then about trends in trade-based remedies? I know there's another panel talking about the ITC in the U.S. in particular. I've learned that there's a similar, although maybe mirror image, procedure or authority here in Korea. Dr. Soon, it'd be interesting to hear from you, maybe to begin, any trends that you're seeing in trade-based remedies.
Well, as I said, there were a few US ITC cases involving Korean companies as both claimant and respondents, and the misappropriation occurred in Korea. One case was filed by a botulinum toxin product producer against a Korean competitor, alleging the misappropriation of the trade secrets relating to its toxin products. At the time when the ITC action was filed, the parallel civil and criminal actions were pending in Korea. Another case, as Taegun mentions, relates to the lithium battery product. As I understand, there were at least a civil action which preceded the ITC action filed by the trade secret holder against another Korean competitor before the US ITC. And as I said, those actions were filed reportedly, perhaps among others, due to the lack of ability in Korea to get discovery from the other party, even if the alleged misappropriation took place in Korea. And although those two cases, as I recall, were ultimately disposed by a form of settlement, but some arrangements similar to settlement, but at least at the initial determination stage, they were both successful, the claimants. So I think with this successful story, perhaps the companies which are located particularly where only limited discovery is available, may think about the US ITC as a desirable option for enforcing its trade secret against their local competitor, as long as they may satisfy the other requirements for the US ITC proceedings. And as I said, perhaps two aspects from my perspective. One is just in view of the broad discoverability before the ITC proceedings was one motivation. And interestingly, after the cases, now there is a very strong movement to introduce one form of discovery in our broad civil actions, and also at least in patent, perhaps trade secret litigations at first. The second effort is led by the Korean Intellectual Property Office. So perhaps I think sometime next year we may have one form of the better discovery system in our trade secret litigation. And the second reason was, as I said, the immediately enforceable injunction. In Korea, unlike the US, as long as an asserted IP right is found to be valid and infringing, the injunction is granted as a matter of right. And the district court, the first instance court, when issuing injunction, routinely allows provisional enforcement. However, in reality, when the losing defendant seeks a stay of the provisional enforcement, the court usually allows the stay. So typically, you can enforce the injunction order only after all available appeal procedures have been exhausted, which could easily span a few to several years. But in case of the ITC, if you get an injunction type remedies, you can immediately enforce that injunction upon the decision of the final determination, as I understand. So that may have been the incentive of the Korean companies to bring the case to the US ITC while they have the parallel Korean litigations. And as the last thing I would like to add that we also have something similar to US ITC proceedings, trade-based remedies for IP infringement. Korea Trade Commission has also unfair trade investigation system where a patent holder or a trade secret holder may seek exclusion order or cease and desist order against those who export the infringing product or import those infringing products to Korea. So, as I said, although in Korean civil procedure you have only limited discoverability, Korea Trade Commission proceeding is not the adversarial system. Strictly speaking, it's just investigation by the administrative agency. So some limited ability to discover the other party's information can be overcome by using the Korea Trade Commission. I stop here.
And I thought that was particularly interesting coming out of, as a US lawyer, that the mechanism here allows for a trade-based remedy on exports as well as on imports. It's not a protectionist system, it's a reputation protectionist system. Anyway.
Yeah, if I generally speak about trend of ITC, why I think that the world know better than me, why I don't know that in that situation, ITC 37 proceeding became popular these days. I think it is mainly due to the fast pace of the proceeding and broader discovery scope. The final determination comes out within 5 to 16 months from the institution of the case, and ITC rarely stays the case even when the relevant IPR is filed. In addition, discovery in ITC is faster and more flexible than that of the federal court. For example, the discovery begins the day after the investigation institute, even before the answer is filed. Whereas in federal court, it takes several months to start discovery. And the response time for the discovery request is limited to 10 days in ITC case, whereas it's 30 days in US federal court. And discovery rule of the ITC is more flexible. For example, the number of deponents and the time limit for each deposition and number of interrogatory can be set with broad discrimination of the ALJ of the ITC. And powerful trade-based remedy of the ITC that Dr. mentioned is another thing that attracts the complainant or IT owners to that ITC proceedings. However, please note that there is a hurdle for foreign entities to use ITC 337 proceedings. So to file that kind of ITC proceedings, the domestic industry requirements should be met. For example, the complainant should have an operation in the US or have invested in the US and etc. This is required because the purpose of this ITC proceeding is to protect US economy. However, I think that ITC is a little flexible in deciding whether this requirement is satisfied.
Just a final note, when I was in-house, because I worked at global companies, the US market was number 1 or number 2, depending on your products. But because of that, the ITC in the US was our number 1 form of choice, because it's fast, you can get results that you want, and it's reasonably foreseeable, can I say, the results. Even many years ago, US companies didn't choose ITC as the forum, right? In the 80s, but it became more popular for enforcing the patents and trying to stop your competitor. So there's definitely a trend in reliance on ITC, and I think that will continue.
Changing the topic for just a moment, and maybe Albert's getting you for a minute. You had made a comment earlier about costs. This is one of the significant considerations in bringing or defending trade secret litigation or international litigation more generally, is the cost of doing so. To what extent does third-party litigation funding play a role in IP litigation matters that you handled or considered?
Sure. As a big conglomerate, you don't need third-party funding, right? But when I'm working as outside counsel, especially these SMEs, the smaller companies, or even so-called patent trolls, they don't have the money to go through expensive litigation, especially in the US. So third-party litigation has been, I don't want to say thriving, but very popular abroad, especially in the US. But interest in such funding is also increasing in Korea as well. I recall recently there's a UK court case, right, where third-party litigation funding was found to be, I don't want to say illegal, but improper use of it. So I think we'll have to wait and see what each country does, but overall, I don't see it being a bad thing, per se. I don't know if my colleagues have any other comments on that.
Yes, third-party litigation funding is an unclear issue in Korea, at least for domestic litigations. In fact, February of this year, a company named Low and Good launched their new litigation funding service for business. And reportedly, they had a record of 20 cases where they provided funding for domestic litigations. And average legal fee they funded was about 10,000 US dollars for domestic litigation. But by the standard of domestic litigation, it's not that small. But it seems Korean Bar Association does not think that's legal. The statutory basis of objection is there is a statute in our Attorneys Act stating that the receiving compensation or sharing profits out of the service of the type of work only lawyers are allowed to perform is prohibited. And therefore, some people have the view that the litigation funding is against that principle. So that is subject to further review and consideration by the court. But as Albert said, at least a number of Korean companies, I also understand, are using litigation funding for their overseas litigations.
So is there a practice in Korea of contingency-based representations of attorneys providing services and taking share in recovery?
Sure, that is not prohibited, particularly in civil litigations, and perhaps I think solo or small size practitioners, perhaps their prevailing practice would be taking up the case based on contingency basis. However, the success fee for the criminal case is now prohibited. That was allowed for a long time. Yeah, but about 7 or 8 years ago, the Supreme Court rendered a decision that is against perhaps public policy. So that is no longer allowed.
Maybe turning in the time that we have left from litigation strategy and thinking about where cases are brought to your counseling role, when you're counseling a client. How do companies that operate in multiple jurisdictions best manage their multi-jurisdictional IP risk and trade secret risk?
First of all, I think it is important to know the practice of procedural operation of each jurisdiction. We are aware infringement case and invalidation case of the same pattern are ongoing at the same time. The infringement court tends to stay the case. I know that this is similar to the US federal court. On the contrast, German courts are reluctant to stay the patent infringement case when the relevant invalidation proceeding filed. This is similar in the US ITC B67 proceedings, as you mentioned earlier. For multinational companies that operate in multiple jurisdictions, they must be aware of what remedies are available in those jurisdictions. For example, if it's a manufacturing operation in a jurisdiction where injunction is easily obtainable, it may be better to keep close eyes on potential claims in that jurisdiction. About injunction, in German, the preliminary injunction is very powerful too. It is very fast and it can be made started without involvement of the defendant, even without no notice to the defendant. And in Korean court, permanent injunction will be issued if there is a patent infringement by the defendant. It is nearly automatically. This is different from US federal court, where even permanent injunction based on the patent infringement is very difficult to obtain after the debate case. And if you, lastly, if you are an in-house counsel handling multi-jurisdictional IP dispute, management of the overall case around the world is important. For example, how to manage local counsels around the world, including their legal fees, and how to manage the face of litigation of each jurisdiction, and how to utilize information obtained from one jurisdiction to another jurisdiction, which must be considered.
Yeah.
I can add something. Yeah. So there's a final comment in our session for me. I want to stress that this is a very cultural thing. So I have a Korean client who was sued in the US, and we had to start the discovery procedure. And it is very difficult to explain what is the discovery, why they have to keep all the documents, why they have to prepare and submit their documents to their party. They don't understand. Culturally, it is unimaginable in Korean culture, Korean litigation system. In Korean litigation system, each party has to procure their own evidence and submit to the court. And the court will examine, and the court will decide. Court will be the fact finder. But here in the US, they totally different, and the Korean companies don't understand. So at this stage of any litigation, I think the attorney's role is to explain the differences, explain what will happen in the future, and make the client prepared for the future happenings, and not to shock the client. And the other one is in terms of trade secret. Yeah, as you know, the definition of trade secret includes the management, the information is a secret. the management is very important, and it is very disputable in every cases. But cultural differences also plays a role here. I had a Korean client, which is a subsidiary of a European-based multinational company. And their culture about this information management is kind of autonomous. They have a policy, their guideline, but they do not enforce it. They let the employees follow the instructions. And when we have to prove that this information is managed as a confidential information, then we just submit the policies, but there's no enforcement. There's no evidence enforcement, then the police officer or court will not trust us, right? So this cultural difference, you have to prepare for future dispute. And as an, especially for in-house counsel, it is very important in terms of trade secret to have concrete policy that can apply for all jurisdiction, especially most jurisdiction like Korea maybe. And finally, we prepared for AI thing before, but I just want to say that AI, yeah, this is also a very important issue. If you have, you do not have policy about the use of AI in business, then the employee may put the information to a ChatGPT, and what happens, no one knows. And there will be a big dispute whether this information is confidential or not. And without policy, there will be whether this information managed as a confidential information or not. So there should be a policy, and there should be some kind of contract with the service provider or software provider about whether the information will go public or not. And you have to understand the point of use. So I think there is important issues, especially this multinational online business in terms of secrecy.
In addition to the cultural aspects, understanding that, just the war story really is interesting. And my whole point is, if you're a company and you're doing business, you can kind of foresee which markets you will enter. So having some IP protection in those countries before you start the business is critical. Many years ago, a non-Korean foreign company came to my firm, and actually they made shopping carts. And apparently a smaller Korean company they were making knockoff shopping carts. And they wanted to do something about it. So we asked them, so what protection do you have in Korea? Your patents? No. Trademarks? No. Utility models? No. Nothing. Sorry, but you can't do anything. How about copyright? They asked me. It's not possible. So if you're a company, just see which companies you're going to do business in, and try to get protection before entering that market. I think that's very important as well. And in particular, if any of you are interested in entering Korea, or if you have legal issues, please seek counsel from my colleagues on the panel. Mentioning BKL, they're excellent firms. The US, of course, you have no. I'm not that helpful. Any final comments or?
I think many things have been covered. Just one thing I'd like to note is that the statute may be different from the real practice. So notably, we tend to say that we have the same bifurcation system with Germany in terms of the patent enforcement, meaning that invalidity and infringement are reviewed and decided by separate tracks. But in reality, it is very different. Some time ago, I encountered very interesting statistics. We found that in the first instance, the patentee's prevailing rate was about 22%. In Düsseldorf, the prevailing percentage was 60%. But the invalidation rate of patent before the first instance of both countries, in Korea about 50%, Germany was 60%. So more patents seem to be invalidated in Germany, but in an initial stage, they could obtain injunctive remedies. And also German injunctive remedies seems to be provisionally enforced despite the other parties here. So it seems very risky from the defendant perspective. And also, as some of you may know, we understand how Albert used to work. I think a few years ago obtained cross-border injunctions from the Netherlands court. So this injunction from the Netherlands court would cover the multiple European member countries. So that quite powerful, and also unified patent court, which started this year, remains to be seen how it will affect the number of cases filed before the US District Court. But ultimately, just based on my limited experience in multinational IP litigations, what the client's objectives are in disputes is the foremost important factor. And then you consider where those objectives can best be accomplished. So from that perspective, unfortunately, Korea was not the top priority in forming strategies or determining certain issues on certain matters. They would be more focusing on the US or European market, which is more important to them from the business perspective, and therefore sometimes, although we know that this way would be the way to get prevailing decision in the Korean court, just to accomplish the client's overall objective, we need to just reserve our arguments or refrain from making the best arguments in the Korean settings. So that's all I have.
Thank you. The distinct lack of heckling from the crowd has resulted in us ending right on time. So I think everyone here is happy to stick around if there are any questions or things we should talk about. But in the meantime, thank you for your kind attention and for attending this session. Gentlemen, thank you for your very insightful comments. Much appreciated.